Hi there. If you're over 50 and starting to think about protecting your family and simplifying things for them in the case the unexpected happens, then today's video is for you. Did you know that roughly one third of people get their loved ones' end of life wishes wrong? That's a statistic from the National Institute on Aging, and it highlights just how critical planning ahead is. But even more important, one of the biggest causes of family disputes is end of life decisions, when it isn't clear who gets to make a decision, what decisions should be made, and when courts need to get involved because legal documents do not exist or had issues. So today we're diving into a topic that confuses many. What's the difference between an advance directive and a medical power of attorney? And by the end of this video, you'll not only understand these terms, but you'll also know why they matter and how to make sure your wishes are honored. Hi, I'm Chuck Roulette. I'm an estate and elder law planning attorney licensed to practice in both Florida and in Minnesota. And before we begin, if you haven't already, make sure you hit the like and subscribe button so you'll be notified when I post new videos like this one. And if you have a question, post it in the comments below and I may answer it in an upcoming video. And if you stay to the end, I'll share some resources where you can discover more. So let's start with the basics. An advance directive is a written tool that outlines your healthcare preferences if you can't communicate them yourself. It's like your voice when you can't speak. Advance directives come in two main forms, a living will and a medical power of attorney. Living wills spell out what medical treatments you do or don't want in specific situations. On the other hand, a medical power of attorney appoints someone, a trusted individual, to make decisions for you when you are unable to. So think of it this way. A living will is your instructions for your care, while a medical power of attorney is who you name to make decisions if you can't. Now, in Minnesota, these two are often combined into a single document called a healthcare directive, while in Florida, they're treated as separate documents. Either way, both states allow you to customize these to reflect your values and wishes. Now, here's the thing. Without these documents, your loved ones might face some serious challenges. They'd have to go to court to get permission to make medical decisions for you. That takes time, costs money, and adds unnecessary stress during an already emotional time. And here's something else to consider. Advance directives aren't set in stone. You can update them as your circumstances change, whether it's a new health diagnosis, moving to another state, or even entering a new phase of life like retirement. So what's the difference between these documents? Again, let's break it down. A medical power of attorney names a specific person, like a spouse or close family member as your healthcare decision maker. A living will focuses on specific treatments, like whether or not you want to be on life support or receive CPR. But here's the kicker. A medical power of attorney can override a living will if there's a conflict. Again, that's why it's essential to choose someone who understands your values and will respect your wishes, even when it's tough. I also suggest that all of my clients name at least one backup person as their agent for healthcare decisions in the event that their primary choice is unable to act. So, for example, if you are married, you likely would name your spouse as your primary agent to make decisions for you, and then perhaps one or more of your adult children in the event that your spouse were unable to act for any reason. So, how do you create these documents? Well, the requirements vary by state, but both Minnesota and Florida have relatively straightforward processes. So, here's a few tips to get started. Talk to your loved ones about your wishes. Choose a trusted person to act as your medical power of attorney. And again, I always suggest you have at least one backup named as well, just in case your first choice is unable or unwilling to do it. Make sure you document your wishes and then work with an experienced estate planning attorney to draft and finalize the documents. At our firm, we specialize in helping families like yours navigate these important decisions. Whether you're in Minnesota or Florida, we can help you protect your family and ensure your wishes are honored. If you're ready to take the next step or just want to learn more, give us a call. You can reach our Florida office at 941-909-4644 or our Minnesota office at 763-420-5087, or you can also visit our website at roulettelaw.com. I'm also hosting an online masterclass where I'm going to be revealing strategies I use with my private clients and their families to make it as easy and inexpensive as possible in the event anything were to happen to them. You'll discover how to avoid probate, wills versus trusts, how to save on taxes and expenses, how to protect the money you leave for your kids in the event they get divorced, and much more. There's a link in the description below for you to sign up. And if you would like to learn how you can protect your home and life savings from long-term care and nursing home costs, I've written a book, Save Our Home, How to Protect Your Home and Savings from Long-Term Care and Nursing Home Costs, And there's a link in the description below where you can download your copy. Don't wait until it's too late. Start the conversation today. And if you found this video helpful, be sure to like, subscribe, and share it with someone who might need to hear this too. Thanks for watching. I hope you found this video helpful, and I look forward to seeing you in either the masterclass or an upcoming video. Be well.